Get ready? Start. 54. Such being the case, it was the state of Maharashtra which had to consider the appellant for remission viz respondent numbers 3 to 13 herein stop. Instead, being unsuccessful before the High Court of Gujarat, respondent number 3 surreptitiously filed the writ petition before this court seeking a direction to consider his case for remission without disclosing the full and material facts before this court. Stop. Relief was granted by this court by conferring jurisdiction on the state of Gujarat, which it did not possess as per section 432 in bracket 7 of the CRPC in the guise of consideration for remission on the basis of the 9/7/1992 policy, which had also stood cancelled in the year 2013. Stop. Taking advantage of this court's order dated 13/5/2022, all other convicts also sought consideration of their case by the government of Gujarat for remission, even in the absence of any such direction in their cases by this court. Stop. Thus, the state of Gujarat has acted on the basis of the direction issued by this court, but contrary to the letter and spirit of law. Stop. We have already said that the state of Gujarat never sought for the review of the order of this court dated 13/5/2022 by bringing to the notice of this court that it was contrary to section 432 in bracket 7 and judgments of this court. Stop. Instead, the state of Gujarat has acted in tandem and was complicit with what the petitioner respondent number 3 herein had sought before this court. Stop. This is exactly what this court had apprehended at the previous stages of this case and had intervened on 3 earlier occasions in the interest of truth and justice by transferring the investigation of the case to the CBI and the trial to the special court at Mumbai. Stop. But, in our view, when no intervention was called for in the writ petition filed by one of the convicts, respondent number 3 herein, this court was misled to issue directions contrary to law and on the basis of suppression and misstatements made by respondent number 3 herein. Stop para change. 55. We have held that order of this court dated 13/5/2022 to be a nullity and non-est in the eye of law. Stop. Consequently, exercise of discretion by the state of Gujarat is nothing but an instance of usurpation of jurisdiction and an instance of abuse of discretion. Stop. If the state of Gujarat had the provisions of law and the judgments of this court and had adhered to the rule of law, comma, it would have filed a review petition before this court by contending that it was not the appropriate government. Stop. By failing to do so, comma, not only are the earlier orders of this court in the matter have been vindicated, but more importantly, rule of law has been breached in usurping power not vested in it and thereby aiding respondent numbers 3 to 13. Stop. This is a classic case where the order of this court dated 13/5/2022 has been used for violating the rule of law while passing orders of remission in favor of respondent numbers 3 to 13 in the absence of any jurisdiction by the state of Gujarat. Stop. Thank you.